I'm correct, then. We received your motion. A decision has not been made of that motion at this time. That will be considered probably at the time that the opinion is prepared in this case.
Understood. Thank you, Your Honor. May I reserve 4 minutes for rebuttal, please?
Go right ahead.
Thank you.
4 minutes.
May it please the court. My name is Charlie Wieland. I am a partner at the law firm of Yates and Wieland in Chattanooga, Tennessee, and I represent the appellant, Mr. Jeromy Tyson Ratcliff. Mr. Ratcliff is asking this court to determine that the trial court lacks subject matter jurisdiction to enter a child support order in this case. If the court agrees with that contention, what we are asking this court to do is to reverse the award of attorney's fees to Miss Neal, who I'll refer to, wife, mother, I'll refer to her as Miss Neal, that is her name now. We're asking this court to reverse the order of attorney's fees to her if the court agrees with the contention regarding the subject matter jurisdiction. If the court believes that subject matter jurisdiction did exist in this case, what we are asking this court to do is to remand the case to the trial court for the child, JTR, who is now an adult of 24 years of age, to undergo a vocational assessment to see if this child, JTR, can contribute to his daily living expenses. So, a brief procedural history on the case, Your Honors. The parties in this case were divorced in January of 2006. A permanent parenting plan was entered for the parties' 2 children who were minors at the time, and child support was set. A modification was filed by Mr. Ratcliff some years later in August of 2018 because their oldest child had aged out at that point in time. What happened at that point in time is the court, of course, removed the child, who was now an adult, set a child support order for JTR, who we're here talking about today, and the court put down an order stating that child support would terminate as to JTR on May 16th of 2019. And of course, the reason why it would terminate at that time is because by then JTR would have been 18 years old and JTR's class would have graduated from high school at that time. And of course, under the child support guidelines, that means that the child support obligation is then discharged. The case at hand, Your Honors, was filed on June 27th of 2019. The appellant, Mr. Ratcliff, my client, raised the issue of subject matter jurisdiction in his answer filed shortly thereafter. And then after that, he filed a motion to dismiss based upon the same reasoning, that the trial court lacks subject matter jurisdiction to hear this case.
Did the child support actually terminate before he filed?
Yes, before the petition was filed. Is that the court's question?
Petition.
It did, Your Honor.
Okay.
Yes.
How long a period of time?
A month and a half.
A month and a half.
Yes, sir. And I should note that that's one of the bases for the motion that's before the court. So the order that I'd like to supplement to the record is the actual order that terminates the child support, because that's not a part of the record because it was done as part of a prior modification, not this modification currently before the court. So I do think it's vital for the court to see that order because there is a disagreement over what that order says. So the court issued an order on July 15th of 2020 which denied Mr. Ratcliff's motion to dismiss the case. And sometime later, in February of 22, the court issued an order that dealt with the majority of the issues, including making a finding that this child, JTR, was severely disabled. However, at that point in time, a child support order was not yet entered, and in December of 22, a child support order was entered for this now adult, and Mr. Ratcliff was ordered to pay approximately $22,000 in arrears, and he was ordered to pay $980 a month in support, quote, going forward. So the presumption being for the life of the child, or for the life of Mr. Ratcliff at least. And also, as part of that order, Ms. Neal was awarded $3,406.50 in attorney's fees. Point one that we would like to make, and the court has already raised the issue. So the child support order terminated on May 16th of 2019. Ms. Neal filed her petition to modify on June 27th of 2019. So there was no child support order to continue. which is the language in the statute that is required under the case law that we cited, both the conservatorship of Jones case and the Shaw case that we've submitted to the court in our briefs. Now, as to this disagreement on whether or not the child support order terminated, I recognize that the court has not yet granted my motion, so I'm going to point to some parts in the record that discuss this issue. So in the order on the motion to dismiss that was filed, Judge Sharp addresses this issue. This is the record at page 67. While the court understands the father's argument that the mother did not file the petition to extend child support until after the current support obligation was to terminate, the court finds that the child was determined to be disabled for Social Security benefits purposes in April of 2019. What the court is saying there, the court is acknowledging that the order terminated, that there was no longer a child support order for Mr. Ratcliff to pay as of May 16th of 2019. And the reason is obvious, because the child was an adult at this point in time, and the child's class had graduated from high school, and that's just basic child support guideline stuff. We know that at that point in time, there's no longer a child support obligation. And then the following page on the motion to dismiss, furthermore, the court finds that the order entered by this court on January 9th, 2019 required respondent to pay child support through May 16th, 2019, which was a date more than 1 year after the effective date of the Social Security Administration's determination date. Here again, the court is acknowledging in its order that child support terminated on that date. And again, I do think that it's vital for this court to look at the order itself so you can make your own determination about what it says. And this goes to the core point of the case, whether or not there was a child support order to continue when Ms. Neal filed her petition. And the answer to that question is that there was not, because the child support obligation had been completed and discharged as of May 16th, 2019. And as we cited in our briefs, both the Jones case and the Shaw case put great emphasis on the word continue. They did a detailed analysis, especially the Jones case, a detailed analysis of what that word meant and why it was in the statute. They looked to the legislative history to see what the importance of it was. And in both of those cases, the court determined, and I should note, Your Honors, that those cases were for divorcing parties who had adult children at the time. And so that is a little bit different from our case, but I'm going to touch on the distinction here in a moment. So,
is this an issue of first impression in Tennessee?
This particular set of facts is, Your Honor. That's correct. I agree with that. But the logic is the same, okay? Because the problem that was presented in Jones and Shaw was fixed by an amendment to the statute. And what the amendment says is that if a child is disabled during its minor life and the parties get divorced during the child's adulthood, then a child support order can be entered at that time, which solved the problems in Jones and Shaw, okay? And the key is that the statute says it must be done at the time of the entry of a final divorce decree or a legal separation decree. The distinction in our case is that these folks were divorced in 2006. We're not here entering a divorce decree or a legal separation decree. We are here talking about a child support modification after the prior order had terminated. So we have to go back to the logic in Jones and in Shaw that says if there is not a support order to continue, then there is no subject matter jurisdiction. The same logic would apply to this case. To touch on the other arguments, Your Honor, I'm going to go to the attorney fee argument now. So the third pleading in this case was Mr. Ratcliff's motion to dismiss for lack of subject matter jurisdiction, okay? And we believe that the court incorrectly denied that motion. And if the court had recognized that there was no subject matter jurisdiction at that time, this case would not have gone on. It would have been dismissed by the time the third pleading was finished. And so as a result, a tremendous amount more in attorney's fees resulted. And we believe that under Wilder, there's a manifest injustice that takes place if the attorney fee award is to stand if this court determines that subject matter jurisdiction did not exist, okay? And then to touch on the issue, if this court does believe that subject matter jurisdiction exists, then it becomes necessary to remand the case to see if this child can contribute to his monthly living expenses. And it's interesting because in the court's order that was entered in February of 2022, there are voluminous references to the idea that this child should undergo a vocational assessment. Just to quote some of the language, the court finds this assessment process and/or training should begin immediately. This is in February 22. Today's June 20th, 2024. It still hasn't happened. And so we still don't know if this child can contribute to his daily living expenses. However, the court finds that it is very necessary that the child be enrolled in some form of vocational rehab in the local area, and that the mother and father should take whatever steps necessary to get him enrolled in a vocational rehab program immediately. And the court also took judicial notice back in February of 22 that the mother had not yet enrolled the child in vocational rehab. And so the trial court told us that it wanted to have this done, but yet it still hasn't been done. And so if this child, under the Lillard case, which we also put in our brief, if this child is able to contribute to his daily living expenses, then Mr. Ratcliff's child support should be deviated in accordance with what this child could contribute. But here again, Your Honor, it is our basic contention. Contention number one, that the trial court lacks subject matter jurisdiction, and the analysis should end there except for the attorney fee argument. Thank you, Your Honors.
You have your rebuttal time.
Good afternoon. I'm Randy Sellers, Bradley County Bar. I represent the appellee mom in this case, Ms. Neal.
Yes, sir.
First of all, I'd like to comment on the questions that were asked of the appellant's attorney. This order that that the appellant wishes to supplement the record with does not have the word termination, terminate, or anything of that sort in it. There is a difference of opinion of what that order means. Obviously, I think this court will want to see that order that's been motioned. I don't know why it wasn't included by the appellant originally, but it wasn't. But that,
Are you
again,
agreeing to the supplement?
yes, sir, I am. I've disagreed when I first saw the motion, but I thought, you know, it's an interpretation. What you'll see of that order is there are no findings in that order. There's simply a math problem, and the math problem is child support is lowered because older child graduated and the remaining child still on, so it drops, support drops to $938, and it says child support will be paid to mom as by way of, I think, a wage assignment. I can't remember if that's in there or not, until the child graduates from high school, which would have been subsequent to that, and that is the date that Mr. Whelan says that the child support actually terminated. And your other question was, did child support terminate? It terminated because Dad stopped paying it. That's why there's such an arrearage, as he mentioned, $22,000. So that was the termination. It was a unilateral decision by Dad to do that. I'll jump ahead to another question before I get into my argument in chief. The question about this vocational assessment having not happened, there's nothing in this appellate record that would tell us that the vocational assessment has not happened up to now. That's not a part of what is here other than the appellant's attorney's statement. Matter of fact, in the motion to alter amend hearing, there was discussion of that occurring, and the fact that what's missing from this scenario is that the appellant still has the right to file a petition to modify if an assessment is out there that does give the child some type of performance or ability to work. And so that's their duty. For them to just say it's not been done and nothing's been changed, they have the duty to modify it if they want to ask the court to do that. So that's not before this court. So let me give you a quick timeline. I think that'll be very important in how this came down. This case has a lot of dates in it. But this is a case about a young man who is now 24, who is functioning to the level of an 8 or 9-year-old, first of all, on the autism spectrum. JTR was born 6/21 of 2000. That's the first date we look at. There was a divorce and child support order for Mr. Ratcliff to pay $529 for 2 kids He received 80 days of time in his parenting plan, and that was ordered January 25th, 2006. So there's our next benchmark. I say that because from then forward, there was an existing and valid child support order, and that comes up in a lot of the cases. Whether can you continue something that wasn't already in effect? Well, yes, here you can, I say, because there was a valid child support order in effect since the divorce. Item number 3, mom applied to the Social Security Administration and received an award that backdated the child's disability, as we've seen these awards do, to the date she filed, which was when? It was in May of 2018. That would be a month before the child turned 18 years old. So there's that finding. That's number 3, 2018, May. The fourth date, as I just mentioned, JTR turned 18 a month later on June 21st, 2018. Dad files a motion next with a hearing of January 2019, where his petition is not to terminate on younger child, JTR, subject to this case, but was to modify child support based upon the older child aging out. That was the basis of that petition, not a termination action. And that's the case, that's the hearing that resulted in the order that is part of the request to supplement this record. And what it says, which again, it doesn't say the word terminate nor anything of that sort. So the next, and by the way, this child being disabled did go to high school. He didn't graduate, though, with a class in 2018 when he was 18 years old. He graduated the next year, 2019, so May of 2019 was his graduation date. That's the next important date. And then, as counsel stated, mom then, about a month or so later, June 27th, 19, files the present action. So very important dates. The statutory basis for mom filing that, as we know, come under TCA 365101 K1 and K2. And this word continue that has been mentioned comes from K1. I've cited these on page 7 of my brief for reference, by the way, if you just want to see them cut from the statute. But it says, K1 says, except for provided in K2, the court may continue child support beyond a child's minority for the benefit of a child. What child? Who is handicapped or disabled as defined by the Americans with Disabilities Act until such child reaches 21 years of age. Well, remember, Social Security Administration did that very thing. That was already in place. Now, that's a collateral matter, but it tells the trial court there's already been a finding of disability before this child graduated from high school or even turned 18 by a month at least. K2 talks about if the child, that these age limitations don't even apply if the child is found to be severely abled, and that allows the court to continue child support, to order child support for any time period it sees fit for the rest of his life, for instance. So that's what K2 is about. It doesn't have any age limitations, any filing dates, nothing in it at all. It simply says if there's this finding of severe disability, you can move forward past 21, so to speak. So that's those two statutes. It seems to be the issue that's been raised is what this word, the court may continue child support in K1. Again, that just applies till 21, but in any event, the cases that the appellant cited, conservatorship of Jones and the Sizemore case, both of those cases have that very thing I brought up a while ago as part of their facts, and that is there was no child support order already in place in either one of those cases. That's the two main cases they rely on. And so their own argument fails from that factual standpoint and is distinguishable from the case at bar. Next, we cite, and they cite, I believe, you asked if it was a case of first impression. We have several out-of-state cases involved in this case. So we looked at the Zellman case that they cited, which is a Virginia case. In that case, father moved, and this is on page 11 of my brief. Father moved to dismiss the petition because it was filed 1 month and 18 days past majority. The court rejected that argument, saying that a continuation can include a brief interruption. It goes to your question a while ago, especially where the child cannot be emancipated because they're disabled. So that was the ruling in the Zellman case, Virginia case. They also cited Red v. Red, a Texas case that's relied upon by the appellant here, basically saying that there were no time limits to file. Their ultimate conclusion was that there were no time limits to file an action if a child is disabled before 18. And again, that fits perfect with this case because the child was found to be disabled before age 18. They also cite the Pal-Cisco case, which is an Ohio case, and the Fenstermaker case, which is Ohio. And those two cases actually broaden the concept that child support can be continued past majority even when there's no prior order in effect. So that makes it as broad as possible. I say that because the state obviously has an interest in disabled children and children in general and their support. And because of that, the state, you would think that the state would not want to construe these statutes so narrowly to prevent someone from having to take care of a severely disabled child. The next question that arises is the child support being awarded before a vocational assessment. Factually, we believe Judge Sharp, Bradley County Circuit Judge, had the ability to do this as a result of the testimony he heard. Well, what did he hear? He heard Dr. Hillner, who is a respected clinical psychologist in Chattanooga, Tennessee, finding that the child was severely disabled. He's operating on the level of an 8 or 9 year old. He's high on the autism spectrum. And interestingly, you don't have this in many cases, but the expert had actually seen this child when the child was 5 years old. So it's one of those kind of scenarios. He saw him then and he sees him now. He's the person in the best place to say this child's operating on an 8-year level or a 9-year level. He said it's highly unlikely that this child will ever be fully employed or obtain independence. He also said only with a great deal of repetition can this child maybe or might, he used the word might, do limited tasks on a limited basis. And by the way, mom, who's had the full-time care of the child, says, her testimony was, there is no way that this child can leave this home and go somewhere and be vocationally tested. Factually, it cannot happen because of the structure he's been in, because of the upset and the trauma that would cause him to literally not be in the house day in and day out. So from that, Judge Sharp said, yes, I do want a vocational assessment, but I don't think I really need one to award child support at this time. And that's what he did, and that's where their arrearage comes from as well. They cited the Lillard case in support of their proposition that this was an error. The Lillard case also had a young female child that was had a job at Lowe's, but she was at a totally different level. If you read that case compared to this 8 or 9 year old functioning child, she was at a significant level higher functioning than the child JTR in this case. And the court found that her income could be considered in whether or not child support should be modified. Also in this case, as to whether Judge Sharp could order support without the vocational assessment actually in hand, is that there was no comparable functionality evidence presented by the appellant in this case. Dr. Hillner was the only expert. He said it was, again, unlikely that any work performance can take place on a consistent basis. And they didn't contest that. Dad didn't contest that, his disability or anything Dr. Hillner said. And again, I've already mentioned that they still have the ability to modify support if some work assessment says, Judge Sharp, you were wrong. Here's what this child can now do. It's their burden to file a petition to modify, not mom's, to do that. As to attorney fees, this is a case where mom protected a severely disabled child's interest. It's not an abuse of discretion. It's a pretty low fee for the complexity of this case, given the difficult issues. Bottom line, someone has to support a severely disabled child, no matter what this court or the outcome of this case is. It'd be a travesty if the child support statutes, and again, I think I've said this, were construed so narrowly as to prevent what the state has a huge interest in from happening. I thank you for hearing me. I think that's all I have. Thank you.
Thank you, sir. Your rebuttal?
Yes, thank you, Your Honor. So I'd like to make 4 points. Number one, on this idea that the order that the court will now see did not terminate child support, I agree it doesn't say the word terminate. The court will read it for itself. But it stops child support, stops terminate. It's all the same thing. His child support obligation was fully discharged on May 16th of 2019. The issue of arrears was also raised. What you'll notice about the filing, or about the court file, is that during this time that Mr. Ratcliff was not paying child support, there was never a petition to enforce, never a motion for contempt, never a statement by mom, hey, I want my child support to keep coming in, because she also knew that it stopped on May 2016, on May 16, 2019. So that's the reason why the arrears were so high, because once this order went down that the child is disabled, at that point Judge Sharp went back and awarded all those arrears. He said nothing in his order about father should have been paying all this time and he's in contempt for doing so and that was a wrongful act by him, because Judge Sharp and Ms. Neal knew that Mr. Ratcliff was supposed to stop paying on May 16th of 2019, and I believe that this court will find that crystal clear once it reviews this order. It was touched on by Ms. Neal's attorney that she filed the Social Security disability claim in May of 2018. So she had ample notice that this child may be disabled. And so she has no excuse for having not filed the petition to continue child support until until June of 2019. So she should have filed and had plenty of opportunity and plenty of notice that she should have done that. And she filed that with the Social Security Administration in May of 2019. There was a finding made by Social Security that the child was disabled in January of 2019. So even then, she had a full 4 months until this child support order ended, stopped, terminated, whatever word needs to be used. So she slept on her laurels in that regard, and she should have filed it in time before the child support order ended, and then we wouldn't be here talking about this issue. But she didn't do that. It was touched on the language in the statute about the word continue. I want it to be, the point to be made that the word continue is also in K2 that applies to severely disabled children, so the same analysis would apply there. I also want to touch on the Red Court's ruling, which is a Texas Supreme Court case that is directly analogous to our case. And I want to talk about some of the language used by the Red Court. The Red Court held that the trial court was only authorized to require child support payments to be continued past the age of majority if the request for continuation of such support was made before the child turned 18. Therefore, in red, the divorce court's jurisdiction to continue the original support order ended when the original support order expired because the child reached the age of majority. It's the exact same situation we have here.
What about arrearage? If arrearage is paid, is arrearage is due, does that continue with the order or what?
If this court determines that no subject matter jurisdiction existed, that means that the child support order ended May 16th of 2019, and any arrearage that has already been paid by Mr. Ratcliff should perhaps be refunded to him in some way, because those are payments that he should have made.
Was the arrearage built up after 2019?
That's correct.
Oh, they weren't due before 2019?
No, all of the arrearage is because he stopped paying May 16th of 2019,
Okay.
because that's what that order said he was supposed to do.
Okay, thank you very much.
Thank you, Your Honor.
That's your time. Your case has been presented to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. I want to thank you both for your presentation. Very interesting issue. You may be excused. Madam Clerk, will you recess the court until tomorrow morning?
All rise. This Honorable Court of Tennessee is now adjourned until tomorrow morning at 9:30 a.m.